The introducers in the, there we go. Yes, we'll accept bill introductions. Oh, yes, please turn it on, yes.
I'll start over. Okay. Chair Thompson and committee, good morning. My name is Noreen Spears, and on behalf of a coalition of organizations, including the Kansas Cannabis Coalition, the Kansas Cannabis Justice Coalition, and the Kansas Cannabis Chamber, I would like to introduce a compromise bill, which is 25 RS 1211.
Committee, any questions or objections to the introduction of this bill? Seeing none, that bill is introduced. Any other bill introductions? Seeing none, we will move on. Committee, I'm gonna hold final action on the couple bills we heard yesterday first, so that we have plenty of time to hear the actually hear the bill. So I'm going to have Jason give us a quick overview of House Bill 2016, which was on the obituary notices for voter rolls.
Yes, Mr. Chairman, members of the committee, House Bill 2016 was the bill that amended the statute authorizing and directing county election officials to remove registered voters from the voting rolls when they were either deceased or disqualified from voting. And in addition to the current statutory official sources for verifying a voter qualification to vote, the county election officers could also use obituary notices published online by a funeral home located in the county of the county election official that reports on the death of the registered voter.
Committee, any questions on House Bill 2016? Seeing none, I would make a conceptual amendment to change the enactment date from the publication of the statute book to the register. And is there a second on that? Second by Senator Clifford. Any discussion? Seeing none, all those in favor say aye. Aye. All those opposed, no. Back on the actual bill. Any further discussion on the bill? I have a motion on the bill. Senator Clifford.
Yes, thank you, Chair Thompson. There being no stiff opposition, I would motion that we pass out, sorry. I'm sorry. Can I have the bill number again?
Very good.
2016, as amended, favorably.
We got a motion by Senator Clifford, second by Senator Faust-Godot. Any further discussion? All those in favor say aye. All those opposed, no. We apologize for the morbid humor, and that bill is passed. Next bill is House Bill 2020 regarding the Department of Motor Vehicles. And sorry, Jason, I'll have Jason explain.
Mr. Chairman, members of the committee, House Bill 2020 was the bill that came over from the House that directed the director of the DMV to submit quarterly reports on driver's licenses issued to non-citizens to the Secretary of State. The Secretary of State is then to conduct an investigation and compare that report with the voter registration rolls, and if it finds a non-citizen appears on a voter registration roll, to direct the appropriate county election officer to remove that individual from the county voter registration rolls within 5 business days. And the county election officer is to notify that person that they have been removed and that they can be reinstated upon providing proof of citizenship.
Committee, any questions on this one? Senator Faust-Godot.
Thank you, Mr. Chairman. Jason, can you tell me again the difference, the definition of restricted driver's license as opposed to, I believe it's temporary?
Mr. My understanding, Mr. Chairman, members of the committee, is that a temporary driver's license functions just like a standard permanent driver's license in terms of the abilities of the holder and what they can, when they can operate a motor vehicle. The only difference is it has a shorter expiration date because of the temporary nature of the person's lawful presence in the United States. A restricted driver's license, my understanding, actually restricts in some form or fashion when the individual can operate a motor vehicle.
Senator Fesquito.
And thank you, Mr. Chairman, again, and Jason. So, and then this would say that individual with that temporary driver's license would have to submit to who and why?
Mr. Chairman, they wouldn't submit anything. The information that the individual has provided to the Division of Motor Vehicles when applying for their temporary driver's license would be collected and would be provided to the Secretary of State as part of this quarterly report submitted by the Director of the Division of Motor Vehicles.
Correct. Any further questions? Seeing none, I would also do a conceptual amendment on this, or move a conceptual amendment to move the effective date in Section 4 from the publication in the statute book to the register. Do I have a second on that? Second by Senator Murphy. Any discussion? All those in favor of that amendment, say aye. All those opposed, no. The amendment, okay, Senator Francisco. So noted on that. We're back on the base bill. Is there a motion on the bill? Senator Blue.
Thank you, Mr. Chair. I move that we pass out House Bill 2020 favorably as amended.
Is there a second? Second by Senator Gossage. We have a motion by Senator Blue, second by Senator Gossage on House Bill 2020 as amended. All those in favor say aye. All those opposed, no. That bill has passed. Thank you, committee, for that work. We will now open our hearing on Senate Bill 196. Oh, was there a, Senator Francisco?
Thank you, Mr. Chair. I was just going to ask to introduce my pages who are here today.
Oh, sure.
And brought with them the copy of the bill. So if they'd stand, Taylor Martin, Anna Sloan, and Elizabeth Rogakis. So pleased to have them here.
Welcome to Federal and State Affairs. Okay, now we're going to open the hearing on Senate Bill 196, and I'll have Jason give us an overview.
Thank you, Mr. Chairman. Members of the committee, Senate Bill 196 creates new law requiring all employers in the state to register with and use the federal E-Verify program to verify the employment authorization of employees who are hired after July 1st, 2025. E-Verify is a now rather long-standing federal program that allows employers to submit information of a potential employee to verify that such person is lawfully present in the United States and authorized to work in the United States. You'll see relevant definitions for the bill in Section 1, starting on page 1 of the bill. Section 2 makes it unlawful to employ an unauthorized alien, contract with that person for work, or contract with another person who employs or uses an unauthorized alien for work. Complaints alleging violations of this statute can be submitted to the Attorney General, who is required to develop and implement a standardized complaint form, or they can also be submitted to the appropriate county or district attorney. An investigation is to be conducted upon receipt of a complaint. And if the investigating attorney decides to bring an action in court for a violation of the statute, they must notify the United States Immigration and Customs Enforcement Agency. If a court determines that a business entity has violated Section 2 by employing or contracting as prohibited by Section 2, the court must order the business entity to file an affidavit within 3 days, attesting that they have terminated the employment of all unauthorized aliens and will not knowingly employ unauthorized aliens in the future. Failure to file the affidavit will result in further sanctions from the court. These are largely in the form of suspension of any licenses that the business entity has to conduct business. On first offense, it would be a suspension for up to 30 days. A second offense is a suspension from 30 days up to 1 year. And on a third offense, the court would order the permanent suspension of the business entity's licenses and revocation of the organization documents that are filed with the Secretary of State's office in the case of an entity that is a corporation, for example. There is a rebuttable presumption that the entity has not violated Section 2 if the business entity is enrolled in and uses E-Verify to verify the employment authorization of those employees and has complied with federal law in verifying the employment authorization of its employees. Section 3 of the bill requires all employers, including public employers, to enroll in and use E-Verify to verify the employment authorization of all new employees. Those are employees hired on or after July 1st, 2025. Again, violation of the requirement can result in suspension of the licenses for up to 1 year. Public employers must also verify that any contractor that they are contracting with to provide goods or services to the public employer uses E-Verify as well. Finally, sections 4 and 5 of the bill deal with tax deductions for wages paid to employees, and they prohibit a business entity from taking in a state income tax deduction for wages paid to employees who are unauthorized aliens. Section 4 requires submission of an affidavit to the Secretary of Revenue with the relevant information regarding the use of E-Verify by the business entity taking the deduction. Section 5 then amends the appropriate income tax statute under Kansas law to provide for an adjustment to the taxpayer's federal adjusted gross income for any deduction that is prohibited under the state law. These changes would take effect on July 1st if enacted, and with that, I'd be happy to stand for any questions.
Thank you, Jason. Committee questions. Senator Fausto.
Thank you, Mr. Chairman. Jason, so you said that there would be additional sanctions or reprimands if that business did not submit a report that they have fired such a person. So what could be the additional consequences to that business?
Yes, Mr. Chairman, the and Senator Fausto, the sanctions are specified in the bill. It's a suspension of the entity's business licenses, and depending on whether it's a first, second, or third offense, how long those licenses are suspended.
Okay. Committee, any other questions? Senator Starnes.
Thank you, Mr. Chair. Jason, are volunteers employees?
The bill actually defines employee on page 1, line 12. Read through. It defines it as any person directed, allowed, or permitted to perform labor or service of any kind by an employer, and then defines employer. Traditionally, there is some exchange of compensation for that labor that is provided to be classified as an employer or an employee, but the bill is not clear as to the status of a volunteer.
Senator Blue.
Thank you, Mr. Chair. Jason, so is this for any business size?
Yes, it's any employer who employs one or more employees.
So if I am a sole proprietor and I'm the only employee, I'd have to E-Verify myself?
I'm not sure that the bill contemplates that self-employment constitutes employment in terms of
Okay.
having to do E-Verify.
Second is, how will the state know if these employees are E-verified? Like, where are the teeth at?
Well, it would be in that complaint and investigation enforcement mechanism. If there is a suspicion or some kind of factual scenario rises to where it looks like an employer has violated a section, a complaint can be filed with the prosecuting attorney and an investigation then is conducted.
So with the investigation, then, as an employee, then or employer, I would just have to say, look, I E-verified this person?
That would give you a rebuttable presumption that you have complied with the law. If you you show your enrollment in the E-Verify program and that you submitted those employees' information to the program and received, a clearance that they were authorized to work.
And it's just once they, after this date, if I hire somebody, it's just one and done. I've E-verified them the one time. I don't have to do it all the time.
That is correct. There's only that one, when you're looking to hire them after July 1st of this year, you would conduct the E-Verify verification on them just that one time.
Okay, thank you.
Committee, any other questions? Senator Francisco.
Thank you, Mr. Chair. So there are already federal penalties for some businesses. So was the state penalties on top of those?
Yes, federal immigration law provides penalties for violation of federal law. These would be these state penalties for these business entities.
And a second question, so if we talk about an employee as any person directed, allowed, or permitted to perform labor and service, except around an individual's personal place of residence. So my husband can do work fixing the disposal and doing things around our house, but since we have a limited liability corporation for some rental property, I would have to E-verify him if he does any work there?
If he is an employee for your LLC, then, well, if he's already employed with your LLC, then he wouldn't be a new hire after July 1st of 2025.
So he's just issued a 1099. Is that considered employment?
I do not have an answer to that.
That's a contract. 1099 is usually contract employer.
There's ample case law over who constitutes an employee for a business, and those would come into play in terms of deciding who is an employee for purposes of this act.
Any other questions, committee? Senator Thomas.
Real quick clarification. From a financial standpoint, anytime you apply for a loan or a mortgage or anything like that, if you're 1099, you have to apply as a self-employed borrower, just for the record on that. I have a question. How far does this go back? Meaning, if I hired an employee 10 years ago and they were let go 8 years ago, I'm not 100% sure in this bill, like, would you be able to go back and use that file from that employee in this bill from like 8, 10 years ago and hold me, the business owner, accountable? I'm just curious.
Mr. Chairman, members of the committee, my understanding is that the E-Verify requirement is only for new hires after July 1st of 2025.
Okay.
So it does not apply to a current employee of the business or a previously terminated employee of the business, is my understanding.
Thank you.
Any other questions, committee? Seeing none, thank you, Jason. Committee, we've got, I'm going to allow 12 minutes testimony on either side, and that excludes questioning time period, just to make it very clear. So I'll start the clock when the testimony begins and stop it. We have 2 in-person proponents. The Attorney General has to get to another meeting very quickly, so I will stop the clock to allow for questions for him, and then start it again so that we have equal time on both sides. So first proponent in person is Attorney General Kobach. And welcome to the committee, Mr. General.
Thank you, Mr. Chairman and members of the committee. It's a pleasure to be back before you again, this time in person. I'll do what you guys always request, and that is avoid reading the testimony. Almost everything I say is going to be outside of what we submitted as written testimony. So I will pause when I'm giving you some statistics that I think might be relevant that you want to jot down. As you know, illegal immigration is a massive law enforcement problem in this country. It has been a massive law enforcement problem in this country for more than 30 years. Jason did a great job of summarizing. I'll add one detail that I think is important to note. On page 3, lines 38 to 43 of the bill, it notes that every investigation has to defer to the federal government's determination of anyone's employment status. So it's not as if there's going to be some judge or some prosecutor or someone in my office trying to make their own decision about whether someone has work authorization in the United States. The federal government makes that determination, and there's a federal provision at 8 U.S.C. 1373C that obliges the federal government to give an answer anytime a state agency asks, is this person illegally present? Is this person authorized to work? So there will be deference to the federal government's determination. No one's attempting to make their own. There was a question about someone who's self-employed. No, they would not be considered an employee of themselves. They would not be covered. As was noted by Jason, using E-Verify becomes a requirement, but the bill also says you are obliged under state law, not by criminal penalty, but by the civil, it's not really a penalty, but by the civil sanction of losing your business license to comply with this. And if you're using E-Verify, that gives you a safe harbor, a rebuttable presumption, and you're highly, highly unlikely to ever run into any trouble. And that's true with the federal government as well. Federal government creates a criminal penalty for employing illegal aliens, but in enforcing that law, they also although they don't expressly give it as a rebuttable presumption, it is generally treated as a presumption that you have been complying with the law if you're using E-Verify. As was noted, it only is forward-looking, so it's only new employees after the effective date of the bill. It's been around for about over 20 years. In fact, when I was working in the U.S. Department of Justice for John Ashcroft in 2002, it was called the pilot program back then, and then shortly after I left in 2003, it was no longer a pilot program, it was the official E-Verify program. I'm going to give you some numbers, and this is where you might want to jot something down if you think it's interesting or relevant. So most verifications take less than a minute. Almost all verifications take less than 5 minutes. It's online. According to USCIS, which is the division of the Department of Homeland Security that administers the program, 96.1% of verifications are approved immediately or within seconds, 96.1% of verifications. Of the remaining 3.9%, most of those are situations where a person has become married and has changed their name, and the name they are now using is not the name that some other federal government document or state government document had. And those are usually resolved within 24 to 48 hours, where they just simply find out that the person's new last name is what it is. Only 1.39% under current stats, are people who end up being unlawfully attempting to work in the United States. So the vast majority of people are, of course, working legally in the United States, but about 1.39% are those illegally seeking a job. According to fairus.org, the Federation for American Immigration Reform, they've looked at the effect of adopting a bill like this in other states that have already done so. They found that illegal immigration fell by as much as 50% in a single year in states with mandatory E-Verify laws. Now, bear in mind, of course, all of these are the number of illegal aliens present in any state is inherently an estimate, but they estimate as much as 50% dropping. There are approximately 750,000 employers in the United States currently using E-Verify. When you go shopping on any given Saturday, I can almost guarantee if you go into more than 2 stores, or more than 3 stores, at least one of them will be an E-Verify user. It is pervasive, it is easy, it's being done by employers all across America voluntarily because they want to comply with the law and they don't want to accidentally hire someone who is unauthorized to work in the United States. Of those 750,000 companies, 65% have less than 100 employees, and 73% consider themselves to be small businesses. And more than 2.4 million hiring sites and roughly 1,400 companies join every year. So it is a popular program, but it is not a mandatory program in most states. And so now I'll give you some more numbers on what the national map looks like. 8 states require all or virtually all private employers to use E-Verify, which is what this bill, you would be joining those 8 states. Those states are Arizona, North Carolina, South Carolina, Georgia, Florida, Alabama, Mississippi, and Tennessee. And I would note there's an error in my written testimony. It says 10 states. It should be 8 states. There are 21 states, though, that have some requirement that not every employer, but government employers, private employers who are contractors of governments, whether they be state or local governments. And so if you add those in, you're up to 21 states that have some requirement that not all employers, but some employers do. And by the way, those 21 states include all 4 states surrounding Kansas. Even Colorado requires contractors of government entities to use E-Verify. So Kansas, if you look at the map, stands out as a state that does not try to track this, does not try to keep illegally present individuals or unauthorized individuals from working in the state. If you look at the map, you'll find that there are only 2 government agencies and their contractors that use E-Verify in Kansas. Those are the Secretary of State's office and the Attorney General's office. You can guess why. So if the governor chose, she could require all state agencies to do what those 2 agencies do and have all new employees be E-Verified and require all contractors to sign up for E-Verify. Business satisfaction levels are very high. I'm sure you'll hear from opponents that this is such a horrible burden on businesses. It's not. It's not even close. According to DHS, they survey this every few years. The last survey was in 2021. 93% of businesses using E-Verify report that it is easy to use. 94% report that it is fast. It's been tested in court, Chamber of Commerce versus Whiting, a bill very similar to this passed by the state of Arizona, went all the way to the U.S. Supreme Court, and the state won. Opponents will claim that it is a mandate or a burden on businesses. Well, it is a mandate, yes, but so is filing your state income taxes for your business, so is registering with the Secretary of State every year, so is obtaining the relevant permits that you might have depending on your type of business, but it is not a burden. In fact, this morning, I asked our chief hiring official in the Attorney General's office, who's been the one doing the E-Verify whenever we hire somebody, and I said, some people are going to claim that this is a burden. What's your answer to that? And she laughed. She said, this is so simple. And then she described what she does. The person has to fill out the I-9 anyway, according to federal law. And she just has to take several elements from the I-9, the person's name, their date of birth, and whatever document they're using. If they're a citizen, they're probably using their Social Security number. If they're not a U.S. citizen, they're probably using their visa number or an employment authorization number. She types it in, boom, it says authorized. You get an answer usually immediately. It's a very easy internet system. I asked how long did it take for you to, they make you do a tutorial. You got to go into E-Verify. Whatever person in your office is going to do this, and just learn how to use it, learn how to type in the information, which is really simple. And she said, no time at all, less than an hour. And so the point is, in less than the time that we've been meeting today, someone in a business can log on to E-Verify and learn how to use it. Lastly, I just want to say that this is really not just about law and order, it's also about protecting lawful workers. Every time someone who's illegally in the country gets a job, that job is no longer available to someone who complied with our laws, who came here legally, who was a refugee and got LPR, lawful permanent resident green card status. People who are doing it the right way. It also competes with U.S. citizens. Oftentimes, these are jobs that U.S. citizens at the lowest rung on the ladder are competing for, and those U.S. citizens lose that opportunity to provide for their families. So at the end of the day, this is really about standing with the American worker. And finally, I would note, as everybody's aware, the Trump administration is trying to restore the rule of law in immigration. And when you have a pervasive law enforcement problem like illegal immigration, you have to have collaboration between the federal government and the states. The states need to help. When you have states like California that refuse to help and indeed try to push back and assist in encouraging illegal immigration within the state, then the federal government has a much harder time. So if you want to see the current administration succeed in its efforts to restore the law, I would urge you to vote for this bill. If you want them to fail, vote against it. I'm happy to take questions.
Thank you, Mr. General. That was 9 minutes, 45 seconds, so the balance of the time will go to our next proponent, but I want to open it up for questions because the Attorney General has to go to a committee meeting. So committee, any questions? Senator Gossage.
Thank you for being here. I've read through the testimonies of the opponents. Couple of questions. It was mentioned that, you know, they would be currently breaking the law. What happens if they are currently breaking the law with the federal government?
So yeah, the federal government requires that the business simply keep the I-9, which is that basic form that every employee fills out. But the federal government is overwhelmed right now. And in the I-9 system, which was adopted in 1986 as part of the compromise amnesty of that year when President Reagan signed it. And Reagan later reflected on it and said that signing that bill was the biggest mistake of his presidency because the current system that the federal government uses, relying on the I-9, is so inefficient. It doesn't give the, you know, that I-9 sits in a file in the employer's office somewhere. The federal government doesn't know what that employee said when he sought that job, what document he provided, whether it was a real document or a false document. So yeah, the federal government does have penalties. The federal government has made employing an illegal alien, or an unauthorized alien is the term, illegal since 1986, but it's been really hard to enforce, which is why the federal government created the E-Verify system over 20 years ago and is encouraging, it's voluntary for businesses, and that's why you have so many that already use it, and is encouraging states to do what we're contemplating doing today.
And if I could quickly, is there a cost to, if I'm a business owner and I'm like, I need to do E-Verify, is there a cost to sign on to E-Verify?
No, these queries are free.
No cost. And why is it that federal law prohibits employers from asking an immigration status of an employee?
Well, I think there's an interesting balance. So the Department of Justice, in enforcing these crimes, has to treat U.S. citizens and those who are not citizens but are here legally, authorized workers, has to treat them equally. So you can't discriminate against. So if you're hiring, you say, I want to hire only U.S. citizens, not people who are foreign nationals. You actually can't do that. And so that's why the federal law is structured the way it is right now.
And then finally, Mr. Chair, we were reading about deficiencies from 2021, hearing that some of the manual photo matching wasn't quite working. There were errors. Has that been corrected since then? Yeah,
they continuously improved the program. So when it was first deployed, it didn't have a lot of photos. You just had names and their status. You're a U.S. citizen. You're a green card holder. You have a work authorization under such and such permanent. But there were no photos. Then and that made it fairly easy, not easy, but easier to circumvent, because if you could steal, Senator Thompson's entire identity and you figured out his social security number, where he lives, everything else, you could present yourself as him. And so that's when they started what's called the photo tool. And they took photographs of people seeking visas, state driver's license photos for states that are willing to give them, and so that has been added, and the ability of unauthorized workers to defeat the system has gone down as the system keeps getting improved. And any system that's 20 years old, and internet system, is going to constantly be improved every year.
Senator Fasquedo.
Thank you, Mr. Chairman. Mr. Attorney General, good to see you. So you gave us do this or do that. There's a maybe in between, but nevertheless. Would a temporary service, so you know how sometimes people will just go to those temp services and they're sent out, would that also apply in this legislation? And, sometimes, people will just need, help for one day. So would they still be technically employed? And would that individual who just needs help for one day be required to report any information? Can you clarify?
Yeah, I can clarify that. So a person who comes in to help for one day in the home or around the home of an individual, no, that person is not an employee. The homeowner, the individual who doesn't have a business, and most likely does not have any requirement of signing up for E-Verify like that. You talked about a temp service. In that situation, depending how it's structured, the temp is probably going to be employed by the temp agency. So the temp agency, if they operate within the state of Kansas, they would have to E-Verify their employees. But it would not fall upon the person relying on the temp agency to do that.
Any other questions? Senator Francisco.
Thank you, and thank you, General, for being here. So I think you said that this did not include self-employed individuals?
Right. If a solo, if it's just you. Now, if it's you
And-
plus one other, then you have an employee. Go.
Then why is that on line 22 of the bill?
Where,
Page
what
one.
page? Oh, right. I see what you're saying. No, if the self-employed individual hires others, then it has employees. No, for example, I have had a solo practice law firm for, I don't know how many years, 15, 20 years. I don't have any employees, but and I don't, so I'm not I'm not an employee of myself. Generally, the law treats, solo practitioners and solo firms as not having an employee. Although for tax purposes, your accountant may tell you that you have to do certain things you might not know. But no, the self-employed individual only becomes an employer if he decides to hire people or she decides to hire people as employees.
Any others? Seeing none, thank you, Mr. General, for your testimony and your questions.
Thank you so much for letting me go first, and I got to rush off to the next committee. And thanks for all the hard work
Very
you guys are
good.
doing this week.
Very good. We have one other in-person, WebEx proponent, and it's Andrew Good from Numbers USA. Andrew, you've got about 2 minutes and 15 seconds. Are you with us?
Yes, sir. Thank you, Chairman, and thank you to the distinguished members of this committee. I'm Andrew Good. I work for Numbers USA. We're the largest single-issue advocacy group in the country with over 6 million members just on Facebook alone. We are a pro-enforcement group, and the reason that we are here today to support this bill is that illegal hiring, as the Attorney General said, has been something that is it's really the top magnet for illegal immigration. We've known that for a long time, going back to Cesar Chavez, of course, Ronald Reagan, as Attorney General Kovach noted. And in the last few decades, with the basic pilot program and that turned into E-Verify, we do have an excellent tool that many businesses use. I don't want to cover too much ground that he already covered, so maybe I should kind of pivot to say this is incredibly popular with the voters. The voters support E-Verify usually in the 70 to 80% range, required for all businesses. They are fully on board with really bringing an end to the illegal immigration crisis that we've had for decades. The lack of enforcement of the I-9 or the inability to enforce the I-9 properly when it's in the file, in somebody's dusty file cabinet at home is the main reason why after the 1986 amnesty, you were right back to 3 million illegal immigrants by 1990, over 10 million around the turn of the 21st century. And an additional group that studied the effects of E-Verify, of mandatory E-Verify in the states that have gone forward with it, is the Dallas Federal Reserve Bank. Went out and studied this, issued a report. They also found that illegal presence in the states that enact mandatory E-Verify laws is reduced by either between 33% in a state like Arizona.
Andrew, I'm sorry your time has expired. If you can just make your final statement, and then we'll hold for questions.
Sure, to 83% in a state like Mississippi. And so you see tremendous benefits. It's not a silver bullet, but it is probably the one single thing that a state can do to actually work on illegal immigration.
Very good, Andrew. Committee, any questions for Andrew? Thank you. And committee does have your written testimony on file as well, Andrew. Thank you very much.
Thank you, sir.
Okay. We have no neutral opponents or neutral testimony. So we'll move on to our opponents. We have one in-person opponent, and that is William Wilk from the Kansas Chamber. And William, I'll start the 12-minute clock for you.
Thank you, Mr. Chairman, members of the committee. My name is William Wilk, Senior Director of Government Affairs for the Kansas Chamber of Commerce. The Kansas Chamber represents small, medium, and large-sized businesses across the state advocating for policies to improve the economic climate in Kansas. On behalf of the Kansas Business Coalition for Immigration Reform, we appreciate the opportunity to provide opponent testimony on Senate Bill 196, which prohibits the employment of unauthorized aliens by business entities and requires the use and registration of the E-Verify program on all business entities. Also with me on behalf of the coalition today is Allie Devine and Phil Hayes to answer questions for the committee. Senate Bill 196 simply is flawed and would be harmful to the Kansas business community. This bill, if adopted, would create an aggressive, invasive, and costly system of employment verification on all Kansas businesses. The goal of this bill is to put a halt to illegal immigration, but with its broad definitions and severe penalties would suppress business operations. This bill, as written, would apply to every type of business entity, from small to large, with the threat of permanent loss to one's business license with failure to comply. First and foremost, as you've heard, since 1986, with the passage of the Immigration Reform Control Act by Congress, it is illegal of any employer to knowingly hire an unauthorized individual in the United States. This bill passed by Congress added provisions to the Immigration and Nationality Act, making it mandatory for employers to verify the employment eligibility of all new hires through the I-9 process. E-Verify is an optional, unless you are a federal contractor, work authorization eligibility verification system run by the United States Department of Homeland Security. The intent of this system is to compare information utilized in the I-9 process records available to DHS and SSA to confirm eligibility. The E-Verify tool serves to weed out individuals who are not work authorized out of the labor pool. Simply put, if the verification does not match up, the individual is not allowed to work. As I stated, E-Verify is a government program to cross-check to verify if an individual is work authorized, nothing specific to their citizenship status. When has a government program been reliable for quickly, timely, and accurate verification? As recent as 2021, the United States Citizenship and Immigration Services Office discovered deficiencies in E-Verify's processes for confirming identity during employment verification. One deficiency was the photo matching process, as mentioned earlier. It is not fully automated and was relying on employers to confirm the individual's identity by manually reviewing photos, precious time away from core functions of business to verify parts of a federal program. Additionally, E-Verify has been proven to be unreliable with several deficiencies. For example, in fiscal year 2019, an error of 280,000 non-U.S. citizens employment authorized without using the photo matching process to confirm their identities. In the E-Verify licensing verification process, the system deemed 613,000 employment authorized individuals who did not meet USCIS's own identification system requirements. Per a USCIS report itself, until USCIS addresses E-Verify's deficiencies, it cannot ensure the system provides accurate employment eligibility results. E-Verify is a system to determine if an individual is authorized to work. The system has no aspect to check the stage the individual is in within the citizenship process. The system is solely used to determine a worker's authorization. For example, one could be verified work authorized but still be deemed illegal. In accordance with 8 U.S.C. 1324B, it is important to note that employers are limited in their ability to inquire of the applicants about their status in the United States other than to utilize the I-9 and E-Verify process to confirm authorization. There are significant potential penalties provided by 8 USC 1324B for these unfair immigration-related employment practices. Since the introduction of this bill, we have been monitoring what the new Trump administration recommends on immigration. The administration has not recommended the mandatory use of E-Verify on all employers in the United States. True immigration reform must come from a comprehensive package pushed by Congress to address security, workforce needs, and pathways to legal work authorization. Section 2 allows a complaint to be brought against a business entity that allegedly employs an unauthorized individual. The complaint, once filed with a county attorney, district attorney, or the attorney general, must be investigated. If a violation is found, then the court shall order the business entity to terminate the employee and sign an affidavit that they have terminated the employee and commit to no further employment. In determining whether the employee is in fact unauthorized, the investigators and the court shall only consider the determination of eligibility provided by the federal E-Verify system. As I have previously mentioned, the E-Verify system makes mistakes documented by the Office of Inspector General. Employers have no opportunity to present evidence that they followed the law. The penalty for violation of the law is temporary suspension, and after 3 violations, a permanent revocation of a business license, a death penalty for a business. Section 4 calls upon Kansas businesses to annually report of items sure to result in intrusive audits by the Kansas Department of Revenue at a time when our national leaders are calling for a retreat of IRS audits. Section 5 authorizes a clawback of income tax deductions for wages paid to unauthorized workers, again expanding the scope of government rather than reducing it. This is a complex bill with many parts that will have significant impacts on businesses. We have prepared a list of questions we respectfully ask to be answered. These questions will help all of us fully understand the scope and impact of this bill should it become law. On behalf of the Kansas Business Coalition for Immigration Reform, we would urge the committee to oppose this legislation. In closing, this bill represents a clear overreach of government into business operations, and its implementation would have a profoundly negative and lasting impact on the business climate in Kansas. Thank you for the opportunity to testify in opposition to Senate Bill 196 today, Mr. Chairman. And with that, myself, Allie Devine, and Phil Hayes with the coalition are happy to stand for questions at the appropriate time.
Thank you, William. Committee, let's open it for questions. Any questions for any of our, well, for William or his conferees? Senator Thomas.
Thank you, Mr. Chair. Well, and maybe I should have asked this earlier, but I didn't think about it. I apologize to the Attorney General. But how many other states have this housed with their AG's office versus, say, the Department of Labor? Do we know?
That I do know. I've been looking. Idaho, they introduced an E-Verify bill. They tie theirs with their Department of Labor. Nebraska has an E-Verify bill, which is tied with their Department of Labor. So it is a little concerning, given that E-Verify is an employment system, that our Department of Labor has no ties with this.
Other questions, committee? Senator Fasquedo.
Thank you, Mr. Chairman. So, well, what you just described, the process of the verification part of this. So are you saying that that verification process, it could be wrong at some point, and how long does that process take?
Yeah, it could be wrong. I mean, it could be just as simple as typing in an incorrect Social Security number, and then that person is not authorized to work, which then, if according to this bill, then that would require an affidavit to be signed and an investigation. And given the way this bill is drafted, the employer has no opportunity to present that evidence that the system was wrong, and so it will lead to an investigation and then the potential suspension of their license. That is uncertain. I know the affidavit has to be signed within 10 days, given on a violation, but then talking in orders of the court, don't know how long it could be, yeah.
Senator Clifford.
Thank you, Mr. Chairman. Question and a follow-up, if you'll indulge me. You probably aren't familiar with Mr. Good's map, but it shows Kansas in lime color, indicating one state agency and its contractors. I presume that's the AG's office, since he mentioned they use it. But might the state, rather than imposing this on private business, impose it on itself as at least a beta test of this system?
Could you repeat the question? I'm sorry.
Would your coalition oppose the state imposing this system on itself?
With that, we'd have to talk with our coalition members just to see.
Follow up? I would let you phone a friend with your coalition partners, but could someone stand up and tell me what's the worst thing? I mean, I'm in an agricultural district, and I meet German Mennonites from Canada who are in harvest. I meet all kinds of folks here in different status, and frankly, this would be devastating to, my district. But I wonder if anyone would like to comment on how, what this does for business. Thank you.
I don't think there's any good portions in this bill. Just reviewing from our coalition, every section is bad, and the more you read it, the more you find of how just negatively this will impact Kansas.
Thank you, William. Thank you, Mr. Chairman.
Senator Francisco.
Thank you, Mr. Chair. Do you have any idea what burden this would create for our court system? I do know that it's already very difficult to get answers and a case through the court. So how complicated would it B, maybe you could find, talk with members of our judicial branch, but I'm concerned about just the court time involved.
Yeah, and given that there must be an investigation depending on the severity of the violation, like I said, it could just be mistyping a number, and that shall lead to an investigation into a court hearing. I imagine it's going to create a massive constraint on the court system.
Committee, any other questions? I just have one. U.S. Code, or 8 U.S. Code 1324A is pretty clear. It's unlawful to hire or employ someone who's an illegal alien.
Correct.
And you give me all these different reasons why we shouldn't be doing that, but we're in violation of federal law. What would be your response to say, do we just ignore law then?
Well, I mean, it's already unlawful, so our members and people of the coalition, I mean, they're authorizing people through the I-9 process. With this bill, it's just the severity of the penalties that could be associated with a violation, and that the employer has no opportunity to present to the court that they did follow the law.
And in this one, there is a presumption that as long as you file with E-Verify and try and go through the process, the presumption is you've completed your requirements.
Correct, yeah.
Correct, okay. Senator Murphy.
Thank you, Chairman. So if somebody on the I-9 just makes up a social security number, which I know historically, I lived in the Texas Panhandle for a number of years, and that was frequently done. So if somebody just makes something up and puts on their, even makes up their name for that matter, what does that do?
I would assume through the I-9 process, they would flag it, and then they would not be work authorized.
How is it flagged if nobody ever sees it?
I'll turn to Phil.
As an HR practitioner for 25 years here in Kansas, we are a temp staffing agency as well. We've utilized E-Verify since 2013, but that was also a voluntary position that we took. The I-9 piece, ICE recommends 11 best practice steps. E-Verify is one of them. The I-9 is certainly mandated for employment in the states, but the E-Verify is not a fail-proof system that's going to fix all of this alone. But the documentation, employers are tasked to accept valid documentation that looks genuine at face value at its appearance. So there's no fail-proof system. The best thing to do is it can't be a one-prong approach. There's nearly a dozen items that ICE would recommend. The other concern that I would have as a business owner is we end up with a patchwork, a quilt work of states with different E-Verify requirements. It's already tough enough to do business in the state in this environment, let alone without another undue mandate that is also going to jeopardize your livelihood of not only your business, but everybody that you're employing and the families here.
Yeah, thank you. My point was that under the idea that the I-9 takes care of it, the I-9 is just something that's kept on file by the employer. So it doesn't really stop anything until there's something further that goes on. That was my only point. Thanks.
Senator Dietrich.
We've been talking a little bit about that I-9 form, Mr. Chair, and I have not used that form to verify employment when I was superintendent. I don't know if our HR department did or not. I really don't know that. But is it your belief that the I-9 is inadequate?
I think the I-9 is inefficient. We've gone through I-9 audits through my 20 years as a business here. It's not an overcumbersome process. That is the one thing that's universal across all states. And so if we're doing cross-state business, that's just going to be another regulation and component. So unless our neighboring states, and unless really it's a federal mandate, you're going to end up with this patch quilt. And I would assume as a super...
he would have used it.
Yeah, he would have used it.
He didn't use
But the E-Verify, you know, it can be said that it doesn't cost and there's no burden either, but there is a cost. Time is money, regardless of how short that is. And if you have multiple new hires in a year, We've actually engaged technology, and we have a monthly fee to utilize that to create efficiency. And for small businesses, whether it's 1 employee or 100 employees over the course of 1 to 3 years, there's still a cost tied to it, let alone jeopardizing that you think you're doing everything by potential new state law, and you can still have your hand slapped and your license revoked. I think that's a pretty stiff penalty when we're trying to fight for all the jobs and the economic development that we have here within our state.
Senator Thomas.
Thank you, Mr. Chair. Can you talk a little bit about those I-9 audits? Because I know when I forget how frequently they were, but when in a supervisor role, I was responsible for answering those I-9 audits, going through the errors and trying to fix them. And we went to a quick online system that was fairly inexpensive. And I had folks that either didn't have an ID on day one that couldn't come back to work the next day, or it did come back as invalid information. We had to term them. So I'm just, talk to me about the I-9 audits you mentioned. How often do they happen? Because the way I remember it is they came in, they gave us a list. They said, we audited it, here are your errors, and we have a timeline to fix them.
So I would say there's informal audits, and one of the best practices recommended by ICE is to do self-audits, or informal audits on your own, but engage an outside firm or other people that are not involved in generating your own I-9s, because you're not going to catch your own mistakes. But auditors, ICE would come in. Typically, there's what I would consider industry targets, where there's a high aptitude of potential illegal individuals or not authorized individuals. So there's a couple of ways that you could go through that. And typically with the documentation, if it's not of appearance of face value, employees have up to 3 days after their hire date. So there's some leeway built into the I-9 process. The E-Verify, I can tell you, we've gotten false positives through the years, and I would venture to say that under this business or under this law, without any due process or the expense of additional litigation, we would be putting our business on the line, because E-Verify is not foolproof. There's more than 8 million businesses in the nation, and only roughly about 1 million businesses are using it. And then you look at the percentages, if we, it's not mandated for a reason, because it's not 100%, and it does have flaws, and I think there's probably capacity issues when you start talking about 8 million employers and 200 million plus employees that would be going through the E-Verify process on an annual basis, or whatever rotation that is.
Senator Gossage.
Thank you. My question is for William.
Okay, thank you.
Do we have any idea how many businesses currently use E-Verify?
We have not surveyed our members. I know there are some that do, but yeah, we would have to survey it to see.
Just real quickly, texted my family's own businesses, Castle Plumbing in Lawrence, and said, do you guys use E-Verify? The answer was yes. Is it hard? No, it's very simple. And so I'm just asking, wonder how many other businesses are already currently using it, and if they could give feedback on this.
I'm happy to. I've talked to some of our members that use it. You know, they do use it, but they have told me there are some problems every once in a while. So it is not 100% accurate. But
the other thing is, I would think that, you know, we would have fewer people entering illegally if there were fewer businesses offering them a job. You know, it's against the law, but we know that it still happens. As a health insurance agent, I remember working with the company who asked me to come and help them with their health insurance. They just came out and said, do we have to provide health insurance for people that are not, I'll just say, they're not really documented? And I'm just like, well, I didn't hear what you just said. I'm walking away. Not going to handle your health insurance. But they knew. They knew exactly what they were doing. They knew who the people were. And sadly, they could hire people for less money than they would be paying somebody legally in the country, because these people are being held down by saying, I can report you at any time, so you better accept, you know, this salary or this payment's terrible, how they are treated. And so I just can't help but think that we have to do something. The I-9 doesn't seem to be getting it, that we have to do something for these people who are purposely hiring folks that they know, hey, it's illegal, but nobody's coming after me. Thank you, William.
Any other questions, committee? Seeing none, thank you, William. Committee, that will close the hearing on Senate Bill 196. A couple notes. On Monday, we'll hear House Concurrent Resolution 5004. There is no meeting tomorrow. Thank you for the discussion and your work today, and we are adjourned.